Hello, and welcome to part two of our three-part series on hiring, Avoiding Legal Pitfalls, designed to give you easily digestible learning you can consume on your lunch break. Let's get started. Today's bite-sized session may have a lot of things you already know, but hopefully a few things you didn't. Background checks and compliance with the FCRA, and we'll be sharing the EEOC's position on refusal to hire based on prior convictions. Even if you are comfortable with the regulations and best practices, there are requirements and subtleties that even experts sometimes miss. FCRA compliance is designed to protect consumers. The FCRA regulates employers that use background reports and the consumer reporting agencies, CRAs, aka your background screening companies, that provide the information. The FCRA applies anytime an employer obtains a background check for employment purposes from a third party. These reports could include criminal history, employment and education verifications, motor vehicle reports, healthcare sanctions, and professional licenses. It is important to note that while the word credit appears in the name of the law, it applies to background reports regardless of whether or not the report includes credit information. Compliance with the FCRA is the responsibility of both the employer and the background screening company. In most cases, the background check will be conducted by a third party rather than by the employer itself. The third party is considered a consumer reporting agency, CRA, for the purposes of the primary federal law in this area, the Fair Credit and Reporting Act, FCRA. As part of contracting with a CRA, the employer should make clear that what the CRA should and should not disclose to it. And as a general rule, an employer should not receive information that it lawfully cannot consider. For example, many states, such as California and Massachusetts, restrict an employer's consideration of certain misdemeanors. So the CRA should be instructed not to report such misdemeanor convictions. After an employer contracts with the CRA, it should decide when to conduct background checks and whether to limit them to certain positions. Requiring them of only certain individuals is inadvisable. If an employer checks backgrounds based on people rather than positions, it invites claims of explicit or implicit bias, which very well may exist. Then there's a question of timing. An increasing number of state and local laws prevent employers from asking about criminal history or conducting a background check until after a conditional offer is made. Even if an employer is not subject to ban the box, referring to a checkbox in an application that asks about criminal records, it ordinarily makes sense not to conduct a background check until after a conditional offer is extended. By waiting until then, an employer is less likely to have a viscerally negative reaction to the existence of any conviction because the employer has already decided that it wants to hire the applicant. The formerly incarcerated are now a source of talent that employers should not categorically ignore, independent of the law. All applicants must sign a background check authorization that's compliant with federal law. The authorization would not be compliant, for example, if the applicant waives any claims that he or she may have had with regard to the background check. Some states, such as California, require a separate authorization. Any form required by a state should be a separate form and not combined with the FCRA authorization, or it may not comply with the FCRA. After the employer receives information from the CRA about an applicant, HR will need to determine preliminarily whether any conviction disqualifies the applicant from employment. In 2012, the EEOC published guidance effectively requiring that employers, in most cases, make an individualized assessment rather than applying blanket rules such as, we do not hire felons for any position. As part of the individualized assessment, the EEOC guidance calls for employers to consider the nature and gravity of the offense or conduct, the time that has passed since the offense, conduct, or the completion of any sentence, and the nature of the job the candidate is seeking. While the EEOC guidance is subject to challenge, its principles minimize an employer's exposure to adverse impact claims. Moreover, an increasing number of state and local jurisdictions are requiring a holistic approach to conducting background checks. For example, New York State requires that an employer consider 8 enumerated factors. New York City goes even further and requires that the employer provide rejected applicants with an analysis of how it applied the 8 factors. Of course, there are exceptions to individualized assessments. For example, securities laws bar applicants with certain convictions from performing certain jobs. Also, most, if not all states, have laws to protect children from sexual and other forms of abuse. These laws generally prevent employers from hiring applicants with certain convictions to perform jobs in which they may have unsupervised interaction with children. If the employer has concluded that a conviction disqualifies an applicant from a particular job, that decision must be preliminary and not final. The next step under the FCRA is to provide the applicant with a pre-adverse action notice. Under the FCRA, the applicant must be given the opportunity to dispute the veracity of any report used to disqualify him or her. Employers are well advised to go one step further and ask the applicant if there's any other information that he or she thinks the employer should consider, even if the report is accurate. This demonstrates that an individualized assessment was conducted as set forth in the EEOC guidance. It's also consistent with the individualized assessment process required by many state and local laws. Employers must attach to the pre-adverse action notice a summary of the applicant's rights under federal law. Some states, such as New Jersey, have an additional notice, and there are special rules that apply in California. Just as the employer should document its preliminary determination, the employer should document the reasoning underlying its decision with regard to any information that the applicant provides. We hope that you've enjoyed this HR mini session, and we will have a part 3. And we hope that you were able to take away something new. Feel free to reach out to us at support@hr-shield.com, call us at 844-4HR-PROS, or visit our website at hr-shield.com. Feel free to watch our other videos and subscribe to our channel. If you enjoy a good podcast that gives you learning in small bites, please subscribe to HR Rescue Podcast, where we address common HR issues, compliance questions, and more.